Hi, carrying on with these videos in relation to challenging and contesting a will and questions that are often raised by clients when they first come in to see me. In this second part of the series of doing these videos, I wish to look at timing. So inevitably right at the very beginning of any instructions that are given, 9 times out of 10 a client will ask, how long is this going to take? And it's very difficult from a solicitor's perspective to answer that question. It all depends upon numerous factors, which include how the opponent will respond to the claim, when it will settle, and also the appetite for litigation. Now, ordinarily, only 2 or 3% of cases go to a final hearing. The rest settle at some stage along the way. Statistically, 50% of cases settle before court proceedings are ever issued. So from the start of somebody coming into the office and looking to challenge a will, I normally say to a client that it will take up to about 6 months in order to get all of the evidence together, to try and correspond and settle matters with the opponent, and if needs be, attend a mediation. From that, as I say, 50% ordinarily do settle. If, however, court proceedings do need to be issued, then pre-COVID, I would advise all clients that would take 12 to 18 months. Unfortunately, after COVID, there is a shortage of staff in the back rooms at courts doing the administration, and these matters are taking longer and longer, and it can actually take up to 2.5 years for a matter ultimately to come to a trial. As I said before, only 2% of cases do get to that stage, and the vast majority settle before proceedings are issued, or they settle when disclosure and witness statements take place, which is normally within about 3 to 4 months after proceedings are issued. What can cause the delay? Well, first and foremost, right at the very beginning, presuming that as the client you are proactive, you want to push this along as quickly as possible. Opponents can be very difficult, they can delay matters, and also you're heavily reliant upon third parties. So, for example, if you're challenging a will whereby somebody does not have the necessary testamentary capacity in which to make the will, we will need to obtain their medical records in the first instance. This used to take only 4 to 6 weeks. It is now common practice that it takes 2 months for these records to come back. Having obtained the medical records, it is also necessary to obtain the previous solicitor's file of papers who drafted the will on behalf of the deceased. That can normally take anywhere from about 7 days up to 28 days, depending on how quick the solicitor on the other side responds. Having got the medical records, having got the previous file, and if necessary, having got witness statements from various witnesses, that can take up to about 3 months. It is then common practice that a letter of claim is sent to the opponents. The letter of claim normally gives them 3 weeks to investigate and to come back with their response. Providing they come back with a prompt response, then the litigation can continue from there on. However, 8 times out of 10 cases, it's necessary to send chasing correspondence, or they're evasive in their responses. As I say, if that happens, it can slow the process down. I would advise every client on day 1 to contemplate going to mediation at some stage. Mediations can be arranged at short notice and can bring the timetable down by quite an awful lot. And I've known mediations take place within 2 to 3 months of being instructed and matters settling, providing that all of the documents are available at that time. Next, in relation to how many witnesses there are, if there are a lot of witnesses or it's difficult to track down the witnesses, again that can slow matters down. There may be issues in trying to locate a will. Again, whilst there is a search that can be undertaken to see where a will is registered, often it's necessary to write to numerous solicitors querying whether they hold such a will in their will bank. Again, those can slow matters down. However, at all times, a solicitor will advise you what steps are being taken. They should put it in black and white on day one, when those steps will be taken, how the case is progressing, what responses have come back, and how it impacts upon the timetable of progressing the claim through. I hope I hope everything I've discussed assists in this matter. But if not, please do not hesitate to contact me. It's Martin Oliver at Right Hassle. Thank you.